He didn't just question the judge, he walked into chambers, called the ruling disgusting, and walked out. What happened next shocked the courtroom.
60FY, People versus Courtroom, Fuller. That's you, sir?
Yes, sir, it is.
You're here with your lawyer, Mr. Ross Truckee.
Yes, sir, I am, John.
This matter is set for a pre-exam conference this morning. It's got some history to it. It was set for a preliminary examination on the 20th of May, I believe the date was, and you didn't show up. So you should have bench warrant for your arrest. You presented yourself in court on the 28th.
In Michigan, a defendant failed to appear in court. When he later turned himself in, the judge followed the law and recalled the bench warrant. But behind the scenes, tension was building.
And I recalled the bench warrant and scheduled the matter for this morning. I asked for a special hearing regarding Assistant Prosecuting Attorney Gary Gabry. His boss, Deborah Davis, is here. Ms. Davis, is Mr. Gabry going to be present?
Your Honor, he's next door doing the sentencings with Judge Pattison. So it wasn't clear from the email what exactly we were going to be covering.
He was extremely disrespectful to me. He walked into my chambers, called me disgusting, stomped out and disagreed with my recalling the bench warrant in this case, which is a violation of the canons of professional ethics and a great insult to me. He also was wrong on the facts and the law. So he needs to be here and he needs to be prepared to apologize to me. And I'd like to make a special record with him present. If he feels he can come into my chambers and insult me and then stomp out because he disagrees with my ruling, he is sorely mistaken. So I want him present. We can proceed.
Your Honor, Mr. Gabry is willing to come in and speak with the court. We would ask that it be off the live stream. It can still be an open courtroom, but we would ask that it not be streamed.
All right, thank you.
I don't know what we're waiting for.
We're waiting for Mr. Gabry.
Is there another hearing in a different court?
I'm sorry.
I thought it was done.
He is. I guess I was hoping the court would.
And I'm doing it on a live feed. If he doesn't wish to be here, we'll make a record. I'd like him to be here. He had a position he wanted to state. I never got a chance to explain my position. So no, if he doesn't wish to be here, then I'm going to proceed accordingly. All right, good morning. Mr. Gabry is here, and we're going to proceed. This is in the matter of People versus Karan Duvar Fuller. Mr. Fuller is here with his lawyer, Mr. Ross Truckee. Also present is Assistant Prosecuting Attorney Gary Gabry and Prosecuting Attorney Deborah Davis. Mr. Fuller was charged in April with being a felon in possession of ammunition. I believe that alleges he had 2 shotgun shells. Anyway, because he is a felon, he's not allowed to possess ammunition, and the matter was charged as a felony. He is on bond on 3 other felony cases, which are all bound over to the circuit court. And he was charged with this. Preliminary examination was set for May 20th. The defendant didn't show up on May 20th. Police officers were here prepared to testify, much to the consternation of all of us, including me. So I issued a bench warrant and set bond at no bond. I wanted to see you personally. There was a warrant out for Mr. Fuller's arrest for failing to appear at that hearing. He called the court that day and said, in the afternoon of the 20th, so I missed my court date. And they said, well, there's a warrant for your arrest. Between the 13th and the 20th, Mr. Fuller came into the court and paid some payments on a payment plan that he was on for some other cases. He didn't show up on the 20th. Then he presented himself at the court. My understanding is Mr. Truckee told him to turn himself in at the jail. Rather than meet him here at the courthouse, Mr. Truckee was here that morning. He went to the jail and sat there for about 45 minutes, but they said they were too busy to book you in. Is that true?
Yes, sir, Your Honor.
So you came from the jail to here. So I'm in the middle of a busy morning with a bunch of other stuff going on, and here you are. Mr. Truckee walked out the door, and you walked in the door. So he was gone. We tried to call him, but he was already on his way to Three Rivers. So here you are, I canceled your bond. It was my bench warrant. And there's a statute that nobody likes, but it's MCR 6.105. It's actually a court rule. So he'd been to the court between the dates. He called the court the date he missed. He went to the jail to turn himself in. They wouldn't accept him. So I went with option 2 of the court rule, which allows him to be presumed to not be a flight risk and appear, which he did. Mr. Truckee was scheduled to be here this morning. He was late. He did call and said he was running late, but he's here. I didn't give him a PR bond. I simply recalled the warrant and reinstated the $10,000 cash.
The prosecutor stormed into the judge's chambers, furious over the decision. Words were exchanged. The ruling was called disgusting, and that single moment changed everything.
Went on back about my business because I had other stuff to catch up from being on vacation. Some point later that morning, Mr. Gabriel came into my chambers. I was in there signing some orders, and I said, "Hey, good morning. I got something I'd like to talk to you about." I had a misdemeanor complaint that was handled by their intern that I wanted to check with him on. And he said, "I have more important things to talk about than that." And he said, "Why?"
The judge wasn't acting on emotion. Michigan Court Rule 6.105 left him no choice. The law required the warrant to be recalled once the defendant appeared voluntarily.
The hell would you give Karan Fuller a PR bond? I didn't have an instant response. I just recalled the bench warrant. I said, "Well, I guess I'm sorry I didn't give you notice of the proceeding," but he just showed up, and I cited the court rule. So I set it for today. So Mr. Gabriel was quite upset. He got up and either said, "This is disgusting," or "You're disgusting," and he walked out of my office. This was ex parte. Nobody else was in there but us. And so I left sitting there thinking either maybe the statute is disgusting, or court rule that there's a presumption if they turn themselves in that they're not a flight risk. If I had done that when I was assistant prosecutor to Judge McManus, Bob Karras would have fired me that morning. When did it become a thing that the assistant prosecutor could come in and tell the judge that he's disgusted by a ruling that he made? I'm not sure when that became appropriate. I don't believe you do it to Judge Stutzman. I don't believe you do it to one of the judges in Kalamazoo. I followed the law. I had an understanding of the facts. I followed the court rule. I set the matter for hearing. He's here today. The offense he was released on was possession of 2 shotgun shells. I don't have the discretion to cancel this bond because Gary Gabriel is mad at him. And I didn't deserve what you came in and said to me. In my career as judge, you've been the most disrespectful attorney to me, bar none. An attorney came to me after a hearing and said, "How long do I have to be a lawyer before I can be as much of an asshole as Gary Gabriel was to you?" I don't deserve that. And I didn't deserve this. I followed the law. I had a better understanding of the facts than you did. I had a better understanding of the law than you did, and he's here now. Make a motion to cancel his bond in circuit court if you're that upset about it. I'm going to send him for a drug test before we're done this morning. This violates the canons of professional responsibility. You have an obligation to treat the court with respect. And your other lawyers with respect. And I understand that you were upset, but you left before I even got a chance to explain myself. So that isn't a thing. The assistant prosecutor can't go into the judge's office and say, "Your ruling sucked. I don't deserve it. I don't deserve it. And I believe I was right, and he's here now." We're going to have a drug test. You have your right for a preliminary examination, which will be next Tuesday at 1 o'clock. And we'll proceed accordingly. So what I expect is you to apologize. I understand that you lost your temper and you're upset about it, and that's to be understood. Nobody liked Court Rule 6.105. It was very controversial with the judges. You either had to let him go or drop everything you're doing and arraign him within 2 hours. As I said, he had turned himself in at the jail and they wouldn't take it. So I set it for this. So that's all I have to say on the matter. Ms. Davis?
Thank you, Your Honor. First, I would like to say that we were not aware of Mr. Fuller attempting to turn himself into the jail. That's the first I've heard of it is today. We'll certainly be following up with that. Our belief is that the bench warrant arraignment is a critical stage and that he should have had an attorney. We had made it clear at the last hearing when the request was made that we felt that Mr. Fuller was a continuing risk. He was involved with felonies. He's not new to this system. He knows how this works. He knows where he's supposed to be and when he's supposed to be there. His pattern of behavior towards law enforcement is extremely dangerous, with fleeing and eluding and resisting and obstructing. And in order to protect society and give our law enforcement the support that they deserve too, we were asking that his bond be canceled and that he be remanded. The concern is now that he continues to be around people who use substances. So his history and not